Hey guys, this is John Watts. I'm a consumer protection lawyer, and welcome to our third video in this series on what does a 1099-C, or cancellation of debt form, do to the actual debt. Now, what we'll talk about in this video is the Gugger versus USAA Federal Savings Bank, but this is the follow-up decision. This is a 2018 decision. In the second video, we took a look at the 2017 decision. And if you remember in that video, the judge said, well, there's arguments on both sides. I'll let the parties do discovery. So what are we arguing about? Well, ultimately, we're arguing about a 1099-C, cancellation of debt, particularly under the Section 6 identifiable event code when we have the code G. So let me get to the code G. And that is, there's a decision or a defined policy of the creditor to discontinue collection activity and cancel the debt. Enter G in box 6. So this is the follow-up case. Now, in this case, we have a summary judgment. So you remember in the 2017 version of this, it was a motion to dismiss. So we're not looking at any evidence, just what did the plaintiff, the consumer, allege in the complaint. Now we're looking at evidence. And so the judge says, while the parties spent the majority of briefing arguing about whether Form 1099-C cancels the debt, this case is actually very simple. It turns on the Fair Credit Reporting Act's fourth element, and that is whether the furnisher discovered inaccurate reporting. The bank submitted a declaration, similar to an affidavit, a sworn statement, stating the consumer owed the debt, it had a lien on its property, and the consumer did not submit any evidence, so the bank wins. The quick background, and again, watch our first video for kind of the quick overview of the 1099-C and the instructions, and then our second video is a 2017 case. So the judge says, look, the bank issued 1099-C with code G, and the consumer says that legally released him from any further obligation. But he pulled his credit report, he saw this debt was still being reported, he disputed it with TransUnion, one of the credit reporting agencies, a couple times, and it did not get fixed. So the court is going to tell us, well, what's the standard? What's the rule when we're looking at a motion for summary judgment? And a summary judgment is just a request by either party that the court not submit either the entire case or part of the case to a jury, but instead just summarily enter judgment in their favor. And so the moving party, that's the one that asked for it, that would be the bank, demonstrates the absence of a genuine issue of material fact and entitlement to judgment as a matter of law. Well, what does that mean? A fact is material when under the governing substantive law it could affect the outcome of the case. So let's take a car wreck. I sue Bob Smith and I say he was negligent. He says he had the green light. I say I had the green light. Well, that's a factual dispute. That's very important. It is, quote, material, because that changes the outcome of the case. Who had the green light? And so the judge talks a little bit more about that. And then says, look, if the moving party, the bank here, carries its initial burden, the burden of production, in other words, having to produce proof, shifts to the non-moving party, that's the consumer here, to set forth facts showing a genuine issue of disputed fact remains. So here's the crux of its argument. The bank says it never intended to discharge the debt, and the debt was never actually discharged. And the consumer responds by saying, well, we need to have discovery. Well, the problem with that argument, which that's a great argument normally, the problem with that argument, and I'm just taking what the judge says here. Sometimes judges don't get it right. Sometimes they don't fully set forth somebody's argument, but we'll just take it like it's worded here. The consumer keeps talking about, hey, I didn't have the benefit of discovery. And the bank says, yeah, you waived your right to discovery. You agreed we would not conduct discovery until after the motion for summary judgment. So the bank argues, cannot now decide to argue the motion should be denied on the grounds he's not had the opportunity for discovery. The judge says, indeed. So again, the consumer says we haven't had the benefit of discovery. And the problem is, during a case management conference with this judge, the parties proposed a stay of discovery until the summary judgment was decided or adjudicated. So this judge, I presume a magistrate judge, specifically asked plaintiff's attorney, is that something plaintiffs would join in, Mr. Charity? To which the plaintiff's lawyer replied, yeah, it's fine. We're fine with that. And the judge says, now you're talking out of both sides of your mouth because you can't agree to stay or freeze discovery so that the bank files this motion and then say, hey, I don't have any discovery, so deny that motion. And the court points out that if the plaintiff thought that he needed discovery, you can file something. So the federal rules of civil procedure in most states are similar. It may be slightly different, sort of subparagraph, but Rule 56D, again, some states it may be 56F or 56E, but same concept, that the party can submit an affidavit or a declaration that it can't present the facts to justify the opposition and that it needs to conduct discovery. So discovery, things like, hey, swap documents, let me send you interrogatories, kind of like being interrogated in writing, and depositions where you get to ask somebody questions under oath live. That could be in person or over the phone or by Zoom. Unfortunately, the plaintiff filed nothing of the sort. The judge said at summary judgment, why did you agree to a stay if you need discovery? Attorney responded, it is his view defendant needed discovery more than the plaintiff did. And the court says, I was really surprised that you agreed to skip discovery because go back to your dismissal or the dismissal motion. And remember, that's a 2017 case. And the court all through here talks about, well, I'm going to give you a chance to do discovery. It says, in light of the arguments made, case precedent, court's order denying the motion to dismiss. And like, for example, court says possible circumstantial evidence as well as Form 109C could show the debt was actually canceled. Thus, it's possible the consumer could discover evidence indicating his debt was actually canceled. So he failed to request discovery or a 56D stay. So therefore, I'm not going to deny, ruling on this motion. And so I'll tell you, I mean, that part, if the judge is setting forth the facts correctly, and I have no reason to doubt that, I think the judge is making the right decision there. Where I think the judge makes a mistake is with the FCRA. But whether I like it or not, whether I agree with it or not, we have to know what the judge says here. So it says there's no doubt Form 1099-C is riddled with confusion to any average consumer. However, how a consumer would interpret 1099-C is not an issue before this court. Rather, whether or not the debt was actually discharged is the issue. Because if it's never discharged, there can be no inaccurate reporting. And that makes sense. So the consumer can say, well, I thought it was discharged, and I think they did a lousy investigation because they should have gotten rid of this debt off my credit report. But if it turns out the debt was not discharged, then that argument falls apart. And we've looked at other case law that says that you have to have an inaccuracy to be able to sue under the FCRA, at least for this type of case. Okay, you could have different types of cases under the FCRA, like an illegal pulling of my credit report. Okay, but in terms of I'm suing for a lousy investigation, then basically I have to show that there was some inaccuracy. And so the court says, well, I find this declaration or this affidavit for this bank senior vendor relationship. Mr. Fletcher says USAA still considers the debt outstanding and owed and maintains a lien interest on the property. And the court, and we talked about this in the first case, there are 5 things that the furnisher, like a bank, must do when it is notified of a dispute under 1681 S2B. They don't dispute the first three elements. Crux of disagreement between the parties is the consumer's belief Form 1099-C canceled his debt, leading to inaccurate reporting, and the bank's belief it did not. The bank attached a declaration evidencing the form did not cancel his debt after conducting an investigation, submitted a declaration stating did not intend to nor indeed to cancel, forgive, abandon, or discharge the debt. And so when the judge says, so they did enough to kind of hit the ball over the net into your court, Mr. Consumer, now you've got to respond to it. Because the bank does not bear the burden of proving this claim, in other words, that element at trial, on summary judgment, as a moving party can meet its burden by presenting evidence negating an essential element of the consumer's claim, which it did. The burden then shifts to the opposing party. Here, the plaintiff, the consumer, maintains the fact that the form was issued at all is itself prima facie case of debt cancellation. However, cannot avoid summary judgment relying solely on the conclusory allegations found in his complaint. And it says he did not attach any evidence, not even a declaration. In other words, not an affidavit from the consumer. And I think what the judge is saying, not even something from the consumer saying, here's why it was canceled. Because the 1099, because of box or code G in box 6. But the court says you didn't do that. And at the hearing, the plaintiff's counsel offered to provide some evidence. So here's a dispute letter, credit report, 1099-C, TransUnion's investigation, and the judge says it doesn't do any good. Okay, your letters disputing the debt, that just shows your interpretation, not any actual proof. And the judge says it comes down to, was the information reported accurate? And the bank's evidence says it was accurate, and so therefore they win. Now, here's my concern with that. What the judge is saying is, hey, Mr. Consumer, because you believed that the debt was canceled, that's not good enough. That's no evidence. But the company's saying, this is what we believed and intended. That's solid evidence. And since they offered solid evidence and you did not, you lose. I don't think that's correct. Okay. Really, the bank, they can sit there all day long and say, well, here's what we intended, or here's what we believe, or here's what we meant. You know, that doesn't really matter to me. And so I understand where the plaintiff's lawyer is coming from, saying, hey, just look at the 1099-C form. Now, I think the consumer's lawyer should have put that into evidence, and it wouldn't hurt to have the consumer say, here's why I believe that it's wrong. But, you know, I think the judge here has missed it a little bit. So what could we do? And look, it's always easy in hindsight. What could we do? Well, maybe we do discovery. And we go up to the bank and we put them under oath in a deposition. And we say, how many of these have you filed, these 1099-Cs? Why do you file them? Okay, so maybe we take a deposition not only of their corporate representative, that's the person they designate to speak, but then we say, in that deposition, we say, tell me who's in charge of making the decision to fill out a 1099-C. And they say, oh, well, that's, you know, Rebecca Jones in accounting. Well, that's our next depositions. We're taking Rebecca Jones in accounting and put her under oath. Why did you do this? And sometimes what you'll find is a company will give contradictory answers. Well, that's great, because that is a material issue of fact that's in dispute. Like the company itself is contradicting itself. Go back to the simple car wreck example. Say I sue somebody and said they were negligent. I say I have the green light. But later in my deposition, I say, yeah, the light was red. Well, they go, well, John said it was red. And I go, yeah, I also said it was green. Well, I mean, maybe that's enough to keep me alive, that dispute. So if the bank was contradicting itself, it might kill the case for them, but at the very least, it should allow the case to go beyond summary judgment. So we question them about this. We question them, what do you do when you file these 1099-Cs? Do you still collect the debt? Oh, yeah, we still collect the debt. Okay. What do you do when you collect that money? Because you've gotten the tax write-off for it. Do you report that money coming in as income? So, not to bore you with accounting and stuff, but just think about it this way. You loan me $10,000. Okay, I don't pay taxes on that 10,000. If I pay you back the 10,000, that's not income to you. Okay? Because you loan me the money. Now, the interest that I would pay would be income to you. But I'm just returning the principal to you. But if you file a 1099-C and say, the debt's uncollectible, and I'm writing it off and I'm canceling it, checking box G, or G, put code G in box 6, then you get a tax break for that. But then if I end up paying you later, that really should be reported as income. So did they report it as income? And you can develop evidence that way to show that this bank is treating this debt as if it's canceled. They're telling the IRS that it's canceled. And again, you would want to question them under oath about, why did you fill out a 1099-C? Why did you put in box 6 right here, identifiable event code, why did you put enter G there when it says you're only to do that when you discontinue collection, which, see, that kind of contradicts this argument that, we thought the debt was still owed, and you cancel the debt. Well, did you cancel the debt or did you not cancel the debt? Which one is it? And so you get some evidence so that you give the judge something to rule on in your favor. And so again, I'm not being critical of the lawyer that did this. It's always easy in hindsight. I certainly can look back on cases I've handled over 25 years and say, I kind of went this way. I should have gone that way on the case. That's just part of it. But, this is something that if you're facing this issue as a consumer, or for the lawyers watching this, if you're bringing this type of case, you got to understand that there is some law out there that would be negative. In other words, it would be favorable to the creditor. But there is some law that's favorable to us on the consumer side. And so that's in conflict. Now let's put the evidence in front of the judge so the judge says, you know what? I think I'm going to let a jury ultimately decide this issue. So I hope that that's helpful to you, and we'll continue to do some videos, maybe take a little bit different course adjustment here. On the next case, we'll talk about when debt collectors write you letters and say, look, there may be a 1099 issued to you for debt forgiveness. Can that ever be a violation of the FDCPA, the Fair Debt Collection Practices Act? Is it always a violation? Is it never a violation? Well, we'll look at, in particular, a case from 2019 from the 7th Circuit, and I think that'll give us some good insight into it. Appreciate you guys watching this video, and I'll catch you in the next one. Okay, thanks. Bye-bye.